Good morning. Happy summer, everyone. Welcome back to Ladies in the Law with Alison Melendez
and Michaela.
So we are excited to continue filming and producing some more content for you guys. How's your summer been so far?
It's going amazing.
It's hot.
Yes,
It's
it's
so
hot. But I always call them my little lizard moments when I'm like, I just need to go sit out in the sun. And just literally, I'm just like, I just need to be outside and feel the sun on my skin. And so that's a lot easier to do when it's actually like warm outside.
Yes. And now you can do it at 8 a.m. because the sun is my window where I work, the sun just hits all morning. So I'm just roasting in there.
Oh yeah. Where it's like, I'm just like reminded of where I'm not right now. But then you're also like, you get a little something.
It's a good break though. Just like lizard moment.
It is. I know. I'm like, I potty my dog and then I'm just like, it's my turn for the sun too.
I love it. So today we want to talk about a little bit more about discovery and some of the things that we see once you're actually in the weeds of it. So on one of our last episodes, we talked about what discovery is. And for today's episode, I want to talk about meet and confer letters and motions to compel. So once you've already gotten the discovery responses, or maybe you haven't, what sorts of next steps we're doing. So I know you do a lot of meet and confer letters. So I kind of wanted to pick your brain on when do you start them? Do you always do meet and confers? And kind of just like explain what they are for listeners that maybe haven't done meet and confer letters.
Yeah, totally. I think meeting and conferring is so important. I think for a lot of reasons, but it just shows that you really have your hands on the case. I think also like when you get a defendant's discovery responses, the first thing I'm doing is like I am reading through it and I am taking copious notes.
Yeah.
Like I have this little template that I created for discovery responses. I have the ones highlighted where like I know if this response is like insufficient or just an objection, like this is worth meeting and conferring on.
Yeah.
And so like I'll go through the responses, I make my notes, I dictate like important things that we get from discovery, and then kind of start bolding ones that are like, oh, they only objected to this, but we're entitled to this information. Like if they're only objecting to like form interrogatories, so like the judicial counsel approved discovery.
Yeah.
And it's a sole objection. It's like, well, we're entitled to this information, so I'm going to meet and confer on that. So I think I read all of the responses kind of twice through, one to just get information, and then the other with like the scope of, okay, what am I going to need to meet and confer on? Is this enough information? Did we get what we're entitled to get? And then kind of that will dictate where to go from there.
Yeah, I think I do the same thing. I do a discovery summary for all the defendants' responses, and then if we get a file from a co-counsel, I'll do discovery or summaries for our clients' responses too. But I think the highlighting method is huge because sometimes they come in and you have something else to do, so just like kind of skim through, come back to these, and then I'll take a second look and like more in depth. So after you identify, so let's start just off with objections. So can you explain a situation where you get a defendant's discovery responses and it's only objections? Like, what does that look like?
Yeah. So, essentially, I feel like a lot of the time when that happens, it's when there's been, it's usually correlated when there's been a good amount of requests for extensions. I think sometimes we always like to err on the side of granting extensions because it's like, it's a courtesy and we understand that sometimes you need more time. I mean, sometimes we have like really heavy appearance weeks. So that might look like we have to go to court and continuously show up. And then it's hard to put your hands on discovery if you're not actually at your computer. Or sometimes it's hard to get in touch with the client. So I think it's having that mutual respect for both sides of like, I understand that you need time now and I might need time in the future. And why would I stonewall you? Because that might impact me later.
We're only human. Like life happens, work happens. And I think discovery is just very time consuming.
Yes.
So everyone's different, but what do you typically do? Do you have like a certain number of extensions that you'll grant before you're just like, okay, it's starting to get out of hand here?
Yeah, I think it honestly depends on the case and my relationship with the defense counsel. You know, if they've constantly been like communicative and I don't think that they're just stonewalling, or I don't think it's a tactic to just continue to delay the case. And if I think like general practice usually will do like 2-week extensions at a time.
Same. Yeah.
You know, because I feel like that's like enough time to kind of like get your hands on it. If they're continuously asking for extensions and it's getting to the point where it's like we're months from when this was originally due, I'm not able to move this case along without these responses, then I think I'll either be like, well, how much of it have you gotten done?
Yeah.
Can you just send me what you already have, and then we can supplement the other ones later so that I can at least start getting some information? Or it'll be requested, the extension will be requested, and I will be like, yes, but this is the last one we can grant so that we can start moving the case along.
Yeah, it's definitely tricky because you have to move the case forward, and it's like you want to be nice, but at the same time, like if you're months out, like come on, you haven't been able to get any information.
Yeah, no, I yes. Have you experienced that on your side? Do you kind of treat it the same way?
It's very rare that I only get just objections. Like I think for the most part, I would say maybe 90% of the time I do get complete responses, and I have a pretty good relationship with the defense counsel. So it's most of the information's there, and most of the information that I need. There's certain things that I might not need and I might not fight because it's not a huge issue to the case. But when it's something really crucial information, like if it's a disputed liability, I need to know how your client is, his version of events. And so if they're just saying like, see police report, like that's not enough.
No.
And I hate when they do that.
I have been getting that so much lately. Yeah. I feel like.
And then same thing with like special interrogatories. Sometimes it'll just say like refer to form interrogatories, but then those only say refer to the police reports. So it's like you're going in circles.
Yeah.
But I think for me, it's meet and confer letters are very time consuming. So I kind of focus in on the big issues that I need to meet and confer on. And when I'm drafting the letter, I try to be very, very specific. Like liability is in dispute. This is why I need this information, and this is why this question was asked the way it was. And I think when you are as specific as possible, it's hard for them to respond to your meet and confer letter saying like, oh yeah, you're not entitled to that, because you're very clear on like why. So I think for people that haven't drafted a meet and confer letter, is there a way that you format it? Like how do you approach drafting a meet and confer letter?
Yeah, so I tend to try and be as detailed as possible, because I never want to bank on the idea that like, oh, I'm going to have to do a motion to compel on this, because I want to believe that we can meet and confer and get to a point where it's sufficient for both sides.
Right.
But I always work with like, how can I help future me? Is like always like my mindset. Like, how can I set future me up for success? And that's by doing a really detailed meet and confer, because the more detailed my meet and confer is, the better off I am for if I have to draft a motion to compel.
Yeah, I agree. I think it's so tedious, but literally just putting the request number, what they produced, why it's insufficient, what we need.
Yes. And
then just going through and being as detailed as possible. In your meet and confer letter, do you put a deadline like I need a response by X date?
Yes, I do every time. Usually 2 weeks.
Okay.
I think 2 weeks to 30 days.
Yeah.
And I always put the caveat of like, if you need more time, I am willing to grant that as long as there's a mutual extension for our deadline to do a motion to compel.
Yeah.
I think it depends on the case and how many I'm meeting conferring on, if it's 5 versus if it's like all four of like the ones that we sent out, where it's like, if it was solely all objections, they're going to probably need more time.
Of course.
Than if it was just 5 questions.
There was one time I got a meet and confer letter for defense, and they had served us with like, it was like 100 special. It felt like 100. I don't know if it was actually 100, but it felt like 100 special interrogatories. And she gave me like a 1 week deadline to respond to everything. And I was like, it's physically impossible.
Yeah.
I need more time.
Yeah.
But usually everyone's pretty reasonable. And I think I don't think I've actually had to go all the way where we've had to file a motion to compel. I think for, at least in my experience, usually we're able to reach an agreement. How about you?
I have done a handful of motion to compel. which like is how I knew like my meet and confers needed to be detail oriented, because there's so much level of specificity you need for motions to compel that like when you set it up the way that you just described, where it's like request number, the original response, and what we need more from, is so helpful, because then you can just take that like what we need more and put that into your motion to compel. Yeah. And then right there you have the deficient. Insufficient. Yeah. What is there?
I think I call it insufficient.
Yeah. Response, and you can copy paste that straight into the motion to compel, which just makes everything so much easier, so much more streamlined. So I definitely have done a good amount.
That's good. No, that's really good. Do you so obviously you have motions to or meet and confer letters when you don't have responses, and when you do have responses but they're missing something.
Yeah.
Have you come across cases where you just haven't gotten responses at all for like everything?
I have gotten that a few times. Yeah. And I know you have too, right? Because I think we were sharing back and forth like the the different motions that we had to file. Yeah. Where they're just like not responding. You're like, if you need more time, let me know. And you're just not getting anything and there are no responses. So then I know one of the motions we do is motion to deem all of the admissions. Yeah.
That
might be like the RFA.
It's early.
What is deem all of the admissions admitted.
Yeah.
And like those kinds of things, because it's like at some point, like we need to do something.
I think it's just crazy to me. I think, well, I don't know. For me, I'm very, very, like I know all my deadlines for discovery, and I'm very cognizant of like, I have a week to get these out. So I've had a few cases where I just don't get responses, don't get a request for extension. And so I pick up the phone, call defense counsel, and I'm like, hey, is everything okay? Did you guys miscalendar this? Like, what's going on? And it just blows my mind when they're like, oh, no, we just don't have them. Like,
yeah,
that's a pretty big deadline. And if we move to admit these admissions, like it could ruin your case.
Yeah.
So that's wild to me.
That brings up a good point. So like for meeting and conferring, do you like to hop on the phone and talk about it with opposing counsel? Do you prefer to do the letter? Like what is your usual tactic when it comes to meeting conferring with the other side?
If it's something about my client, I'll hop on the phone. So if I receive the meet and confer letter, and let's say there's certain records that the defense attorney wants that I know are private, or there's very specific information, and there's things in there that are unrelated to the lawsuit that I can't produce out of protecting my client's right to privacy, then I'll hop on the phone and I'm like, look, there's this information. We're happy to redact it and produce the records, and I'll attach a privilege log of what's being redacted. But I just want you to know, like, I'm doing this in good faith. I'm protecting their privacy. I'm not trying to be difficult.
Right.
But if it's something where, like, if it's a really heavy meet and confer letter, I will just send the letter first, and then if they want to, I'll hop on the phone. But I think it's just easier for me to have the letter broken out and then go through. What about you?
Same.
Yeah.
Pretty much the exact same.
Yeah.
I think that I like to do the letter because it holds me to like, okay, which ones are really worth meeting and conferring on?
Yeah.
And then I think it's easier for both sides to kind of have that visual, you know, of like, okay, like I'll put the law in there, but I'll also be like, we are entitled to this information because it's directly relevant for these reasons. Yeah. Like I can also give like what I would be saying on a phone call anyway. But I think I like to do the letter first.
Yeah.
So that they can have that touch piece too of just like, okay, like these are the numbers. It's easier to do that than like having to scribble notes while you're on the phone. So I think that that's just a good like roadmap to like start at.
For sure.
And then kind of take it from there.
Yeah, I agree. I think 90% of the time, the information that we're fighting for is not like anything crazy, but maybe we can give a few examples of meet and confer topics. So for example, I kind of just touched on one. So if there's prior records of maybe similar complaints, but they include some of private information, that's definitely come up for me. I'm trying to think of other examples that maybe you've come across.
I've seen some where it's like the series where it's asking about the incident itself. And so it's kind of like you talked about where there'll be like sea traffic collision report. Yeah. And it's like, right, but I need you to describe the situation, or it'll be like client doesn't have this information, but it's like literally about the incident that they were involved in. So it's like, where there are things where it's like, I think that they might know a little bit more than they're saying. So those are things that I would meet and confer on because those are directly relevant to the incident. That's information that we need to have.
Why not just get that information in deposition?
I do both.
Okay. Yeah.
Because I think that that's important to have if there's any contradictions. And so I like to have something in writing, and then I'll still definitely ask that in deposition.
Yeah.
But I want to make sure that it's consistent and continues to be consistent.
Oh yeah. And I think I've had it too where sometimes the way that the traffic collision report's written, the defendant driver doesn't agree with that. So then if you're just saying, look at the traffic collision report, but then in deposition, your client's saying that it's not how it was reported or that the statement was taken incorrectly, then you're barely finding out at deposition versus having that knowledge beforehand so that you can prep for your deposition.
Exactly.
So definitely think it's important to take the time to meet and confer, work with opposing counsel, and definitely highlight key issues. I don't think you have to fight over every single thing.
Pick and choose your battles.
Of course.
For sure.
Of course.
Because there are things that like, okay, maybe a deposition is better suited for me to get that information. And I don't want to sit here and look like I'm trying to just like nitpick because that's not productive either at the end of the day.
Oh yeah. And I think if you file a motion to compel very like things that are not key issues to the case, I think the judge is going to be like, really?
Why are we spending time on this?
Exactly. So I think being just cognizant of your time as well, because it takes time to sit down, read all the responses, draft the letter, and then work with defense counsel. But at the end of the day, that is what discovery is about. It's the spirit of discovery is to work together and fact find, but also do it in a way that's productive and helping your client and you don't have to fight every little battle that's maybe not relevant to the case. So
exactly.
Awesome. Well, I think that's our episode for the day. Thank you so much for tuning in, and we'll see you guys next time.